All right, ladies and gentlemen, welcome to another weekly news update. I'm contributing writer Jake Fogelman, joined as always by Reload founder Steve Gutowski. How are you, Steve?
I'm doing good. Jake, how you doing?
Doing pretty good. Big news.
Though?
Yeah,
After last night?
We don't have to talk about my Broncos. Everyone saw how pathetic that performance was.
Yeah, I'm an Eagles fan. I'm just not doing good after watching that last night. So
you're used to watching high quality football. That's why.
Oh my gosh, that was, boy. You know, those warnings of the President Biden gave of Armageddon. Initially, I was very concerned. But then I watched that game and I was like, all right, it's fine.
Sweet relief.
Bring on the global thermonuclear war.
Yeah, we're feeling that too.
To live anymore after watching a full game and overtime of that, whatever that was.
A kicker battle. But anyways, you had a big story this week, a huge court ruling in federal court on New York's Bruin response bill. If you want to tell us what happened with that decision. Yeah.
Well, New York told the federal courts, thank you, sir, may I have another. And they got their second serving here. The federal district judge, Sotheby, issued a temporary restraining order against nearly all of the controversial portions of the new GunCarry regime that the state passed earlier this year in response to Bruin. And, it's all the stuff that you kind of would expect to be blocked. The Times Square ban, they created a whole section of the city that they consider Times Square, even blocks and blocks away from what everyone would consider to be Times Square, and made that off limits. He blocked that. He blocked, he basically gutted the good moral character clause, which allowed a lot of subjective inference by the permitting officials on whether or not somebody has a good moral character. He basically said you can't enforce this unless you make it into an objective standard, and you have to use the preponderance of evidence. And he added a bunch of preconditions to that. He blocked the requirement that applicants submit their social media history, and said that that's not historically grounded. He's using the Bruin standard, so he's going through and doing historical analysis of all these regulations, trying to find analogies back in the founding era, and for the vast majority of them, he couldn't find any, of course, because they didn't exist. Interestingly, this judge is fascinating to me and how he's handled this whole case. This is the same judge, right? And you wrote about this back when it happened initially, but he dismissed the first attempt at this case on the grounds that the plaintiffs didn't have standing. But he went through and basically litigated the case anyway on the merits, and told the plaintiffs how they could get standing, basically, right? And so then they did that, and now he's blocked this law, and he's gone through here in this decision and done all of the research to try and find historical analogs for these laws or these provisions, because New York refused to do that, apparently.
Yeah, he even includes that in the opinion. He talks about, I noticed that the defendants didn't bother doing any of the briefing to do historical analogs, but I'm going to do it for you here.
Right. It's, I don't know. Well, I don't think I've ever seen a judge do a case like this. I'm not a lawyer, so, keep that in mind, but I've followed a lot of federal cases, and I've never seen one quite like this, with how the judge Sotheby has performed in this case, because he's kind of like giving advice to both sides of this issue and trying to do their work for them almost, in some ways. In fact, even at some points, he literally rewrites the law. He's if you can't enforce this provision unless you include, for instance, churches. There was a total ban on having carrying a gun into a church anywhere in the state. And he said that's, doesn't comport with the Constitution unless you add an exception for people who are duty bound to protect the church. So like if you have somebody who's appointed your congregation's security guard or something, they can carry a gun. Or if they live at the church on premises. So I guess, the pastor, in some circumstances, they can carry a gun. And so he's literally changing the way these laws are written. And then at one point he blocks one of the provisions and then writes out literally in the opinion how they should rewrite it to be in compliance with the Bruin ruling. So it's pretty fascinating. But he blocks enforcement of, temporarily, at least as a temporary restraining order that he's issued, the vast majority of the controversial opinions, including the provision where they tried to flip on its head private property rules. So New York had tried to make it a crime to carry a gun on any private property, including businesses, public businesses, unless that business posted a sign saying that guns were allowed. And the judge found that this was, there was no historical analog to a regulation like this, and that it also dealt with issues of compelled speech. And, it was taking the decision out of the hands of the businesses, since they'd already been able to bar people from carrying on their property if they had wanted to. And so he blocked that provision, which was a significant one. This one we talked to Professor Robert Leiter at George Mason University about. Was one of his big concerns. So that got blocked. A lot of the permitting requirements, requiring people to give list their family members that live with them for some reason, and requiring them to have in-person meetings with the permitting authorities. All these things got struck down in the ruling, as well as the vast majority of the controversial gun-free zones that were put up. Right. So they didn't strike down the entire law or block the enforcement of the entire law. You still allowed, reference requirements for the application process. He's still allowing, the gun bans at permitted events run by the government. So, parades and things like that, or protests was another one. That's probably one of the more controversial ones that actually was allowed to stand, is a ban on carrying at protests altogether. So, but carrying where the alcohol is served, that got blocked, that's actually an interesting one, because a lot of states have that provision or something pretty similar to it.
Right.
Some states will do it only for bars, where the majority of revenue comes from alcohol sales or something like that. But he found there was no historical analog for regulation like that. So that could have further reaching implications beyond just New York and some of these copycat laws that are being considered in California and elsewhere. But a pretty significant ruling, right? And you wrote an analysis on what exactly it means, right?
Right.
In the immediate future here.
Yeah. So he, as you said, he did put a block on this law, but he actually stayed that block for 3 days to give basically New York officials a chance to decide if they want to appeal or not.
Right.
And
that's
sure
important
enough,
to note.
Sure enough, before the end of the day, they filed an appeal with the Second Circuit. So as of right now, all of the law is still in effect because the block hasn't taken effect yet. So we'll have to see what the Second Circuit does, whether or not they accept the appeal, and then once they do, how they're going to handle the restraining order. So that's important to note. This is kind of one of the sad realities, I guess, if you're a gun rights advocate, is that even though you got this good ruling, it might not actually have a practical effect immediate, in the near future or ever, depending on what the Second Circuit actually does. Right. I would imagine that if the Second Circuit reverses his ruling, that gives Gun Owners of America and the other plaintiffs in this case a sort of clear path back to the Supreme Court, which I would imagine is
going to be more willing to take a case like this
Sure.
on a expedited basis, given that the law is just as he keeps going. You read this ruling, and he keeps going through it, and it's like basically saying, "Did you even read Bruin?" He keeps citing Bruin over and over again. Like,
Right.
look, they said this stuff. It's not. Why did you do that?
Right.
This is obviously not going to stand. And so I would guess the Supreme Court would want to act on a law like this.
Right. And that, I think, is one of the bigger portions, regardless of what happens with the TRO, between this ruling and then his previous one where he ended up dismissing the suit, but he still did pretty much a full analysis of the law anyway, are two of the most thorough post-Bruin legal analyses that we've seen. Some of the other TROs that we've covered in the past, like the assault weapons bans in Colorado cities, a couple very short, there's a couple pages basically saying, yeah, I don't think this comports, and we'll just kick it and we'll see what happens as further proceedings take place. Whereas Judge Sotheby here, these are like 50 plus page TROs where he's going step by step by step, applying how he sees Bruin applying, which I think is going to be crucial because, we're still in the very nascent stages of the post-Bruin world of Second Amendment litigation. So there's not a ton to go off of just yet. So the more federal courts there are that are applying this stuff, the more you get a body of case law for future litigation. I think that's where this is the biggest impact of this will come.
Yeah. No, I totally agree. Bruin is still in its infancy, essentially, as a standard for how to decide these cases. And now his ruling is going to be one of the very first to dive into the type of historical analysis that the court is looking for, the Supreme Court is looking for. And so I think it makes it pretty influential. That's my guess as to how this is going to turn. It's probably going to be, as you wrote in your piece, a pretty influential piece of case law